You know, indeed, here it is today. I have something very, very important. I think it's very beautiful. Studying confessions and Miranda rights. Today, we found I'm outside of the Franklin Court Fragments building. So what I learned today was there's a difference in Pennsylvania, maybe even like New Jersey, with a New York law. In New York, the rule on confessions, there's a rule on confessions in New York that's pretty different than Pennsylvania, I could say at least. It's a distinctive rule. The rule is no questioning by a police officer is admissible to the court unless the defendant waives his right after initially talking to counsel first. Right? Now, in Pennsylvania, regardless of anything, if you say you want to waive your rights and talk to police or something like that, then your statement will be admissible to the court unless, of course, you coerced or if your due process rights were violated somehow and things of that nature. But aside from that, in Pennsylvania, it's pretty straightforward. If you waive your rights to speak to a police officer or some kind of police officer in whatever capacity, then it's going to be admissible to a court. Now, in New York, like I said, it's pretty different. This is interesting. I just learned, I was reading and stuff like that, that the New York rule is regardless of waiving your rights without your attorney being present, they can't use it, or you can't waive your rights without speaking to your attorney first and then waiving your rights furthermore after. That's pretty interesting in New York. So third, I have three rationales of providing testimony to police officers or anybody in that capacity during interrogation or anything like that. Three rationales that's very important. Involuntary confessions. 1, involuntary, as if you were coerced or forced or threatened, right? 2, coercive police techniques, right? A lot of different, if they promise you something or anything of those natures, just little crafty techniques to, coerce a person, and then the other one is, of course, violating your due process rights, trying to hold you for 5 days or 20 hours without you seeing your attorney. All that kind of stuff would be like violating your due process, where if you make a statement, it wouldn't be admissible. So those three factors right there, three rationales: involuntary confession, coercive police techniques, and not free or rational choice, violating your due process rights. Just some, pertinent information for today, for this week so far, right? Indeed. August 7th. Today we have another topic that I was able to study and get slight information on. And we were in the second edition of Prosecutorial Misconduct. Right. Prosecutorial, provoked mistrials, isolated misconduct. Isolated instances of misconduct rarely implicates protection from double jeopardy, right? One of the facts that I was reading, one of the laws and, rulings, prosecutorial, provoked mistrials, in second edition is the book I'm reading it from. I took the notes from it. Isolated instances of misconduct rarely implicates protection from double jeopardy. So, I'll continue. Bad faith or overreaching requires more than one misdeed, right? To have a claim of bad faith in the prosecution or overreaching from the prosecution, it typically requires more than one misdeed by the prosecution. Right? Failure to disclose whereabouts of eyewitness after defense has rested their case. Failure to disclose whereabouts of key witness after defense rests their case. So in other words, prosecution in a circumstance like that fails to produce the whereabouts of their witness, their key witness, all the way up until the point of the defense team resting their case, and then they bring in their key witness, right? Even when found egregious or flagrant or inexcusable and an insult to the institutional values of an orderly trial, such as an act standing alone did not rise to the level of misconduct sufficient to bar a retrial. So, all that being said, withholding information, withholding a key witness from a trial proceeding or a court proceeding to try to gain an advantage over the defense and stuff of that nature, it's an isolated misconduct is what it would be deemed as. Maybe flagrant to the court, maybe inexcusable, but it wouldn't necessarily be sufficient enough to bar another retrial. It might be a reason for a mistrial, but it may not be enough to bar another trial. So another retrial, right? So I just wanted to talk about that because again, some of the tactics, some of the things that defense attorneys may have to deal with, some of the stressful circumstances and the tactics, man, the chess moves and everything like that. And again, we went over some testimony statements and stuff like that, as far as some of the Miranda rights and how that goes in different states and stuff like that has maybe their own laws and case laws that they follow and stuff like that. I know New York, the rule on confessions was no questioning by police is admissible to a court unless defendant waives right after they have initially consulted with their counsel. In Pennsylvania, I know that's not the case. In Pennsylvania, if you waive your rights before you get to speak to your attorney, that admission of confession will be admissible unless you are coerced or you've been threatened or promised something of that sort, and unless they violated the due process and you can prove that. Otherwise, it would have to be not free or rational, of a choice and whatnot. So, just some good pertinent information, some valuable concepts, thinking about things from a defense point of view with confessions and, witnesses, prosecutor misconduct, things of that nature. Esquire up, no bending.